Hello, and welcome back to Nevada Legal Services Now. We are here for the live presentation of the eviction moratorium update, and obviously some things have changed in the last 12 hours. I guess 12 hours is a little bit of an exaggeration, but essentially last night. So we'll go ahead and get into it, but obviously there are some changes that will affect what we were going to discuss today. But I am Ray with the Reno office of Nevada Legal Services.
I'm David, in the middle of a tenement.
And I'm Ashley with the Reno office.
All right, so we will go ahead and get started. So we're going to kind of go through the current status of the moratoriums first, and then get into more depth about what that actually means for the summary eviction process and the eviction process in Nevada. So as of right now, as far as Directive 25 partially ended the moratorium on August 1st, that still remains in effect. So that means that if you live in a mobile home park and own your mobile home, you can be evicted for failing to pay rent. So that essentially means all mobile home evictions are now allowed. If your landlord has sold the home or there's a foreclosure, those are now also continuing to be allowed. And then summary eviction based on nuisance and lease violation is still allowed.
Also, one fine point, if you're renting a mobile home, it's still not allowed to be evicted for non-payment. It's only if you own the mobile home. Actually, you have less rights in Nevada, which is usually not the case, but with regard to the moratorium, it is.
Right. It does change how we're going to talk about how you can be evicted. So in that sense, you do get more protections and more time. But yes, as David said, he's correct. This only applies if you own your home. If you are renting a mobile home, then you are a tenant under Chapter 118A, which we'll get into what the governor announced last night, still continuing to prohibit non-payment of rent actions. So as of September 1st, though, part of the moratorium also did end. So if there was a continuing prohibition until last night at 11:59 on no-cause evictions, but no-cause evictions are now allowed. That was not part of Directive 31 that continues the moratorium. And then obviously it also means that homes can be foreclosed if they are not FHA loans. That also includes any stays of any evictions prior to the moratorium getting put into place as of March 30th. So that means if things were filed in court before March 30th, but then stayed pursuant to Directive 8, those can continue for everything we just talked about.
And, something to keep in mind, we have seen landlords who think within the last 7 days of August, I can give a 7-day pay rent or quit. So that notice is void, the landlord can't proceed, and it's a rather odd way of viewing these moratoriums, but it has happened, so you should know that.
Right. What Directive 25 did make clear is that anything that was issued before during the moratorium, that notice is void unless it was, in court before March 30th. So if you were issued a notice before September 1st, for no cause or non-payment, obviously non-payment of rent we'll get to, but for no cause, that should also be void. All right, so what is still prohibited? Last night, the governor instituted Directive 31, which prohibits evictions for non-payment of rent. That's basically it.
Well, let's clarify a little, and I won't say everything, but it bans summary eviction under NRS 40.253 for non-payment, or 45 days, basically.
And what that distinction means that summary eviction is prohibited for non-payment of rent, but it might technically mean a landlord could go through the formal eviction process for non-payment of rent. Landlords don't technically do that or don't generally do that.
Talk to an attorney, though, if you're going to pursue the plenary process.
Yeah. It does mean things should not happen as fast, although, because it's evictions, courts do process those faster than normal cases. But, you know, if you do get served with a formal complaint and it has a summons attached to it, that is the formal process. And you probably need to give us a call or give an attorney a call to contest it, because it is possible that that could go through. All right. Well, landlords and tenants are still encouraged to work together. The governor basically said that this was because of some of the things that have been happening, making sure that rental assistance applications are getting processed, DETR to continue processing PUA claims. And of course, the courts have not formally adopted rules for a mediation program. So the extension for the non-payment of rent evictions is until October 15th at this point for a 7-day non-payment of rent notice.
Those are considerations. You know, I don't doubt the governor, but in Clark County, for instance, they've paid out 1.7 million out of a possible 30 million. And the 10 million really isn't going to help because they don't have the caseworkers to process the applications for rent assistance. So it's nice that there's a 45-day continuance of the moratorium, but we would probably see these same problems October 14th. Is that me?
Sorry,
Ben?
was that, are you done? I apologize. Something started talking on my computer. Sorry. All right. And then I just wanted to also mention, because recently HUD has instituted a moratorium, a continued moratorium on evictions in FHA insured loans. So what that means is if your landlord, essentially if you rent from, rent a single family occupancy, like a house or a condo, and your landlord has an FHA loan, that means your landlord cannot evict you through December 31st. That also means that your landlord also can't be foreclosed on through December 31st. So HUD did essentially issue a new moratorium, or extended their FHA moratorium until December 31st. And that does apply to all evictions. They did not restrict the type of eviction. So it does mean that, I will say it's not that difficult to determine whether or not your landlord has an FHA loan. You can simply go on the recorder's office site for your county and look up your landlord's deed of trust. And that deed of trust will have on it pretty clearly whether it's an FHA loan.
And probably we need to say it's usually if it's like a fourplex where the owner is living there along with you, because usually a single family home is owner occupied to qualify for an FHA loan. So we're not going to see too many absentee or second homes that are financed through FHA.
Right. So it's of limited applicability, essentially.
Very limited, yes.
Yeah. But it is easily determined if your landlord has an FHA loan, and then that moratorium would apply to you. All right. Again, still no late fees for this period of March 31st through or March 30th through August 31st. I just left this in here just to be clear that your landlord cannot charge you back late fees. Now, one thing that Directive 31 did not do was extend the prohibition on late fees for this 45-day period. So I think, your landlord still cannot charge you late fees for that period of Directive 8 and Directive 25. But it did not appear that the late fee prohibition was extended under Directive 31. So just your landlord can't make you pay back. Sorry, go ahead, David.
Sorry, I'm just saying another layer of complication, and it really, for people who are watching, plan ahead.
Right. I mean, it really is just 45 days for moving parts to kind of try to get on track. We shall see. And just these late fees can never be collected. So even if you enter into a payment plan with your landlord, you are not required to pay back any late fees from either March 30th through July 31st for mobile home parks, or March 30th through August 31st for other residential landlord-tenant relationships.
And then this is just a quick reminder, we are monitoring the comment section. So if anyone has any questions, don't hesitate to comment your question and we'll try to answer them.
I threw up my hands, like, if you're charging late fees today, is it based on the previous moratorium rent? And that's possible, right?
Well, no, because if you're charging late fees today, yes. If you're charging late fees on September 5th or whatever September 2nd, depending on what the lease says, then no. I mean, it does have to be current rent for September.
Right. Okay.
Yeah.
Right.
Yeah. So rent for September, if you do not pay September rent, you probably owe September late fees. But it can't be based on if you pay, if you paid up and you pay September rent, then they can never collect the late fees for the other months. All right. So that kind of ends our current status update. Again, if you're at all confused or sort of missed what we said regarding Directive 31, please let us know in the comments box. But the rest of this presentation will really focus on how the eviction process works for those evictions that are currently allowed. So we're going to primarily talk about the summary eviction process, and then we'll talk briefly about the formal eviction process that David mentioned earlier. All right, so for lease violations, essentially the tenant is required to be notified with a 5-day notice of the lease violation. That tenant then has 5 days to cure that violation, and that notice must tell the tenant what they did wrong, essentially, and allow them that cure opportunity. That notice is then followed by a 5-day summary eviction notice. It's actually a 5-day notice of unlawful detainer, which triggers the summary eviction process. So it's one 5-day notice telling you what you did wrong, and then a second 5-day notice telling you how you need to move forward to contest the eviction. So that notice does not have to be filed in court to be valid. It does have to be served by a licensed process server, sheriff, or if your landlord has an attorney, that attorney can serve you. But essentially, that notice does have to tell you how you can contest the eviction. And that's primarily by filing a tenant's affidavit in court. So if you're not familiar with Nevada's eviction process, please be aware that your landlord does not have to file anything in court to evict you. They simply have to issue you these notices, and then you have to respond by filing a tenant's affidavit with the justice court. Otherwise, the landlord can seek an eviction order from court without any further notice to you. So those 2 notices are all you get. If you do not file in court within that 5-day time period, your landlord can simply ask the court for an eviction order, but they do have to get that order before they can lock you out.
And not paying the rent is not a lease violation.
Correct. Now, unfortunately, entering into a payment plan and defaulting on the payment plan could be considered a lease violation. So, to a certain extent, obviously take that for what it is. But if your landlord is alleging you breached the lease for non-payment of rent, that won't fly under 40.253. Now, for a lease violation notice, tenants can request a stay of execution. It does mean that you're still going to be potentially evicted. There's likely going to be an eviction order entered, but you can ask for an extra 10 days, and that notice has to advise you of your right to do so. And that's just 10 more days to move out if you lose at your hearing. And just remember, for lease violation, for all of the notices except the last one we're going to talk about, which is the no cause notice, the notice does have to allege facts that support the lease violation, and they have to advise you of what you did wrong and allow you that chance to say, no, either I didn't do it wrong or I cured it or whatever it is. So landlords really should be alleging facts sufficient to support the violation. Otherwise, it is subject to challenge in court. And again, as I said, tenants have 5 days to cure any lease violations, which is why there's that 5-day notice period. Anything else about lease violations, David?
No.
All right. Moving on to nuisance notice, which is also allowed still. This is a 3-day notice, again, followed by that 5-day notice. And everything we talked about the 5-day summary eviction notice still applies. So the notice has to advise you of your right to contest it in court. It has to advise you of your right to request a 10-day stay of execution. It has to be served on you properly. So the 3-day nuisance notice, though, also again has to allege facts sufficient to support the nuisance violation. So not just you did wrong, it has to actually say, you committed a nuisance because you did XYZ on, whatever time frame we're talking about. The nuisance definition in Nevada is also contained in NRS 40.251. And so, a nuisance really is something that is serious. So it's an ongoing conduct or condition that constitutes an unreasonable obstruction of free use of property and causes injury or damage to the building or other tenants. Again, tenants are required to file an affidavit to get a hearing to raise a legal defense. If there is no hearing, this violates the law. If you file the tenant's affidavit, but you have to file that tenant's affidavit. If you don't file in court, the landlord can simply go to court and ask for a lockout order. And generally speaking, because of the definition of a nuisance, because of the, things that are required to be alleged to constitute a nuisance, this is the one that we contest, I'd say, most frequently in court, because landlords don't do this right usually. And then finally, what is still allowed as of September 1st is the no cause notice. And this is the 5-day tenancy at will was already allowed. That was allowed in prior evictions, but we're going to talk essentially, this is, the process is essentially the same. Although a tenancy at will does actually have a definition, it is included with the no cause notices in 40.251. But now 7-day no cause and 30-day no cause notices are allowed. The notice has to advise the tenant of the right to request an additional 30 days to remain due to age or disability. So if you are a family member disabled or 60 years of age or older, you can request an additional 30 days before you have to move out. Again, if you are in a term lease, the lease agreement has an end date that has not come yet, you cannot be evicted with a no cause notice. Also in subsidized housing. So if you live in a complex that's funded by HUD or is in a tax credit property or the public housing, so one of the housing authority owns it, or it's a USDA property. In all of these housing types, you always have to at least be evicted for good cause. Some of them have higher standards than that, but at the very least, your landlord needs good cause to evict you, can never evict you on a no cause notice. And that's the only exception to that is a tenant-based voucher. If you have a Section 8 voucher through the one of the 3 housing authorities in Nevada, this does not apply to you. Your landlord can issue you a 30-day no cause notice, but again, you have to be in a month-to-month tenancy. You cannot be still within your lease agreement. And again, this does need to be followed by the 5-day summary eviction notice that tells you how to contest and where to file the tenant's affidavit. And then the one prohibition is the 30-day notice still, because you can be evicted without cause if you're in a month-to-month or week-to-week tenancy, your landlord still can't issue you a notice if it's based on or pretext for discrimination or retaliation under 118A500. Or sorry, 510. Anyway, sorry. I might get that reference wrong. It's either 500 or 510.
510.
510. So I was wrong.
It's also important to keep in mind, sometimes you get more than one notice. And this probably goes without saying, but if you do get more than one notice, a no cause and a nuisance, for instance, the landlord's really doing that to bring up the nuisance. And if the landlord doesn't win, the no cause, which is usually a sure winner. But you do, as a tenant, need to address both of them.
Correct.
And then we have a question about, it looks like a lease expiration. It says, I rent my 1-family home and my renter's 1-year lease has expired. Can I submit to renew renter lease? Her 1-year lease expired October 1st.
Expires October 1st or expired October 1st? So October 1st this year?
Yeah, I would assume so.
And the question is, can they renew the lease?
It's, can I submit to renew the renter lease? So I'm unsure if it's a tenant asking if they can renew or a landlord asking if they can renew.
Yeah, well, certainly you can renew any lease agreement. There's definitely no prohibition on renewing a lease agreement at all in this context. That's definitely up to negotiation between the landlord and the tenant. All right. So that is the summary eviction process for the currently allowed evictions. Again, we're still not talking about non-payment of rent because the moratorium on rent actions under the summary eviction process was still stayed until October 15th. But we're going to move to the formal eviction procedure and just address this briefly. And this is if you own your mobile home and live in a mobile home park. If your landlord was foreclosed upon, or if you're the owner of a property that went through foreclosure, obviously this is before the moratorium, then the new owner has to use the formal eviction process. And as I mentioned before, that's a summons and complaint that's served on you by, again, under 40.280, it has to be a licensed process server, sheriff, or staff of an attorney's office. So once you're filed with a complaint, you can file an answer to contest the eviction. Your landlord will also most likely ask for an order shortening time to give you less time to answer, and that's usually shortened to 10 days. The landlord can also apply for what's called a temporary writ of restitution, which means that you would have essentially a hearing before the trial date in order for your landlord to try to convince the judge that they are entitled to possession of your home before the actual trial. This is an extraordinary remedy. It really should be treated as such, although we often see that it is not. But you are allowed to just show up for this hearing. You don't have to file anything beforehand, but you do need to show up at this hearing. And that hearing can't be held less than 11 days after you're served.
It's important to also emphasize that this could be any of the reasons for eviction, not just a mobile home non-payment or an eviction after foreclosure. So this could follow a nuisance notice, this can follow a lease violation notice, and unfortunately it can follow a pay rent or quit notice under 40.2512. So we just need to make that point.
Yes, and the reason we don't usually talk about it in this context is landlords mostly choose the summary eviction process, but right. David's right. It is possible that landlords are not going through summary eviction and choosing, the landlord can decide what process they want to use. So it is possible that you could get a summons and complaint for any of the reasons allowed under law.
Prior to 1967, this was the procedure in Nevada. This is the only procedure.
Right.
We have a couple questions. One is going back to the lease that expires on October 1st. And the question is, can the landlord raise rent? It is from the landlord. So I guess just going over the requirements before raising rent.
45 days. The landlord has to issue a 45-day written notice of the rent increase. I guess a tenant can waive that right if they sign a new lease and the rent is higher. But that's basically the requirements.
And then we have a question about, it looks like a payment plan. It says the lease expires in expired January 2020. He spoke with an attorney who told him to reach out to the managers out of good faith for a repayment plan. Managers did not reach out to me. Instead, a third-party company did. What should I do next? And I'm assuming that the answer will be, if you have questions specifically about payment plans or specific issues with your landlord, you should give us a call so we can do an intake and see if we can assist you. But
yeah, I don't really understand the third-party company aspect of this.
Yeah.
Maybe it's
it could be like property, sometimes the name of the managers are different than the property owners. I don't know.
Yeah, I mean, it has to be an actual agent of the landlord. So you're probably a good idea would be to confirm that this person actually has authority to act on behalf of the landlord. But if they do, I mean, that should be clear.
Okay, that's it for the questions right now.
So one thing we mentioned for the Directive 31 was allegedly to give, the courts more time to adopt the mediation rules that were allowed under SB 1, just to kind of readdress the SB 1 issue. There are two proposals, I believe, were submitted to the Supreme Court. The Supreme Court has set a public hearing on the mediation rules. I believe that's scheduled for September 22nd. And then after that, depending on what's adopted, the courts then choose whether or not to adopt those rules for their local rules.
Well, okay, let's note that in Directive 31, Sisolak does away with that notice and comment period. So why the Supreme Court's doing it, it kind of indicates that they don't want to take responsibility either. And if there is a hearing, it's because the Supreme Court wants to have a hearing, not because it's required. And of course, this hearing is going to slow things down. We need a process in place by October 15th, and we're probably, we'll see if we get it.
Yes, that's kind of been our modus right now, is wait and see what ends up happening.
And if the Supreme Court if the Supreme Court wants to force this on inferior courts, it can do it. It did that with Directive 8. It can do it with the mediation program. It's just a question, you vote for judges on the Supreme Court too, so they don't want to alienate too many people by doing this. And just because the legislature didn't take a hard line and take a position and kick the can down over into the Supreme Court, doesn't mean the Supreme Court has to do the same thing. And I think they're going to kick it down to the local justice courts, and they're going to see that very few justice courts buy into this mediation program. Currently in Clark County, it's a voluntary program with neighborhood justice. And how that's going to do any good, it's not, because neighborhood justice wants people to come together in a sort of general sense. And you don't do that with a manager or a landlord and a tenant.
We do have a question. Is there any reimbursement programs for landlords that are not getting their rent?
So, reimbursement, yes, let's just say yes. So there are a lot of programs out there for tenants to apply for rental assistance. If tenants apply for these programs, that money goes directly to the landlords. So, if you are a landlord and your tenant hasn't been able to pay the rent, we can actually, I can move on to that slide. Tenants can apply for rental assistance. Now, the tenant does have to apply for that assistance, but if they're approved, that money goes directly to the landlord.
Then there seems to be a question regarding habitability. Says they started a petition in October 2019 due to pest control. Landlord hasn't fixed anything. But then it's followed up with my eviction got sealed, but the battle still continues. So if you are a current tenant and you have a habitability concern, I guess, do you guys want to talk about what your options?
Sure. Habitability issues always require prior written notice on your landlord. So I'm not really sure what you mean by petition, but essentially the notice needs to give your landlord 14 days to cure any habitability problems with your unit. One of which is that the landlord is required to make sure that the unit is not, free of vermin infestations. So if you provide written notice to your landlord, you must give them that 14-day period to make good faith, or was it reasonable efforts to cure the problem. After that 14 days, there are certain remedies that you can then institute. Generally, for something like a vermin infestation, I don't know that you can generally repair and deduct. You can only repair and deduct if the cost of compliance is 1 month's rent or less. You can also withhold rent. So if your landlord does not fix the problem within that 14 days, you can then lawfully withhold rent after that 14-day period expires. You can also terminate the rental agreement and then sue for any actual damages.
During a moratorium, though, your rights under NRS 118A, 350, 360, 355, you can't, withholding the rent doesn't really do any good because there's a moratorium. So you're not paying the rent. And moving out doesn't help. It's it's helpful for tenants in that they don't have to pay, but if they have substandard housing, it's actually worse.
Yeah, I mean, again, the real remedy for that is you have to provide that written notice first. But
Sure.
you know, if you're incurring damage, if you're paying to try to fix the problem yourself, that is monetary damage to you, which you can attempt to recoup from the landlord.
And then we have a follow-up question from the landlord whose tenant's lease is expiring October 1st, wants to confirm that that landlord has to give them a 45-day notice to raise rent.
That's what the law requires. It's not really us. I mean, it's the Nevada legislature in probably 1977. So go back and complain to them.
But I think if the tenant's asking if the new lease raises the rent, if you're going to enter into the new lease, then you could potentially agree to a higher rental agreement without the 45 days notice.
Right. I think you'd have a tough time as a tenant arguing you should get 45 days notice when you agree to it and start paying it. What was I talking about? Planning ahead?
And yeah, and it looks like someone responded stating, if you notify the tenant today or of the rent increase, it would go into effect October 15th.
Correct.
Yep.
Which essentially means November 1st, unless the rental period is the 15th.
Sure.
Yeah.
David, I don't know if you wanted to talk again about the Clark County ordinance. I just kind of left it in there, but.
Well, it was a step in the right direction. It does require county enforcement. There's possible jail time that's associated with it, or I think it's a $3,000 fine. But basically, if you're a landlord, you can't base your rejection on the source of their income, whether it's Social Security or Section 8 or anything like that. And also, if an eviction is based on a COVID reason, they lost their job and were evicted. I don't know how that's going to happen, but potentially you would be violating the Clark County ordinance, and the county could investigate you, shut you down, take away your license, or fine you, or prosecute you.
Yeah, that eviction based on COVID-19 is a little interesting to see how that would play out.
Right.
And then this does end the presentation. So if you do have any additional questions, please feel free to put them in the comments. But I did want to just put this back up. If you are interested in applying for rental assistance, these are the places that you want to start. In Reno, there are two places. It's housing assistance at reno.gov, or the Reno Housing Authority
Right.
has
Reno,
rental assistance available for tenants.
22,000 has been dispersed in Reno, so they have money available, and they want people to apply.
Right. In the rural communities, you're applying through the Nevada Rural Housing Authority. The website for that is up here. And then in Clark County, unfortunately, there's a variety of different agencies that have the funding. It's not as centralized as it is up north, but the list is on this website. But as I said, that does conclude the presentation. If you do have more specific circumstances and would like to see if we can answer them in an actual, setting where we can talk about your facts and circumstances, please feel free to give us a call. You can also submit an online intake on our website, nlslaw.net, and click on online intake to see if you qualify for our assistance. Any final thoughts, David?
Just stay tuned, because this seems to be changing almost every day.
And then Lucia Starbuck from
Yes, I just saw that.
yes, she is asking if what is our biggest piece of advice to tenants and landlords in Nevada right now? David's speechless.
Well, I mean, again, I hate to be a broken record, but it's planning ahead. So if you're not going to have any money, if you're not going to be available, if nothing is going to be available to pay the rent, then you should let the landlord know and see if there's a agreeable sort of move out date, something you can negotiate. I mean, even if you have nothing to offer, you still have something to offer, because if the landlord doesn't have to do the eviction, that's going to save the landlord time and money.
And we do have a comment, someone saying start a payment plan if you're behind on rent. And I would just caution that with kind of piggybacking on what David said about planning ahead, is only enter into a payment plan if it's something that you can actually, follow through with. Because if you then violate that payment plan, now we're going to have other issues too. So yes, landlords and tenants should work together. But this, if the payment plan is a solution, then it does need to be something that the tenant can, reasonably pay and actually work. I've seen a couple where it's just like, the payment plans are so outrageous, like no one can afford, essentially that significant increase of rent with the payment plans I've seen. So just be careful with the payment plans, make sure that they're something as a tenant that you can actually, fulfill.
And just encourage everybody to apply for rental assistance. There's a lot of money that's still available. I know that there are some programs in the north that have exhausted their previous supply of rental assistance that came through like the original CDBG money, which I know a lot of people don't understand what that means, but original allocations of additional CARES Act money. But there is still a lot of CARES Act money that's available for tenants. So please apply for rental assistance. Again, in terms of like what's required, I know that there are some restrictions on who can qualify for rental assistance, but I encourage everyone to at least apply for it if you want to continue living in your current unit.
One other thing too, and it's part of the governor's problem, is when you change it at the last minute, then people are going to think in mid-October he's going to do it again. So I can't say he's not going to continue the moratorium, but I think you need to plan your life for the worst case scenario, not the best case scenario.
Right. And that just piggybacks on what Ashley said. If you're unable to afford the payment plan that your landlord is proposing, take that into consideration in terms of how you're going to manage, the next 45 days.
And then there was a follow-up question about assistances for landlord or tenant, and someone already responded saying, yes, assistance is for the tenants, which is true. So the tenants have to be the one to apply for it. And then we have another question going back to that third-party company with the payment plan. It states third-party company works with the apartment for utilities and other amenity charges, but the problem is I already pay utilities for Nevada Energy. Once again, kind of like what we mentioned, for more of these like fact-specific questions, it might be worthwhile giving our office a call to see if it's something that we can assist you with.
And with that, I put our phone numbers and our website address back up. I noticed our screen went blank. So again, if you do have any questions that are a little bit more specific that we can answer in this format, please, as Ashley said, feel free to call us. These are our toll-free numbers, and you should be able to get routed to the correct person, but the first number is technically the one for Southern Nevada, and the second number is the one for Northern Nevada. Good Lord. All right. It keeps going blank. I apologize. But I think that'll do it for today. Thank you all for giving us a listen in terms of the update. I know some things changed last night, so thank you for bearing with us. And again, please feel free to contact us if you have any additional questions. And yeah, thank you, David, and thank you, Ashley.
Thank you.
Thank you. Bye.
All right. Have a good day, everyone.